90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we're going to discuss the mediation process. Mediation is an alternate dispute resolution where the parties are involved and agree on the resolution of their dispute. As we'll hear from our panelist, Marilyn Genoa, an attorney and a mediator, and Jess Bunshaft, who also is an attorney and a mediator, and he heads Synergist Mediation, which is a mediation provider that can help resolve disputes. The courts also have their own mediation disputes, but you may be in court a long time before you have that opportunity available. Marilyn and Jess, welcome back to Law You Should Know.
Thank you.
So mediation is certainly the way to go for a quick, low-cost resolution of legal disputes, and it's more important than ever as the courts are backed up and having technology problems in responding to the pandemic. How does someone get the mediation rolling?
It varies. There isn't one answer. Sometimes it's because a court orders them to mediation. Sometimes it's because in their agreements they have, if there's a dispute, first we're going to go to mediation before we proceed to litigation. It can be the attorneys having discussed it. It can be a litigant saying, I heard about it. Can should we do mediation to their lawyer? So originally it can be any way that, there are lots of different ways to do it. And then they would reach out. If it's through the courts, they'd be going to the court system panels or whoever's referred. If it's private, they usually reach out to a mediator they've heard of or a firm that they've heard of. And if there's an agreement, they provide that agreement. Otherwise, they will enter into a mediation agreement with the particular place.
And Jess, what are your thoughts on that?
Just one thing to stress is that functionally it's much simpler than litigation. Unlike the courts, there aren't certain forms that have to be filed, certain steps that you must follow your cases out. It can be as simple as, if you're using our firm, you go to our website, you click on the info to contact us, and you reach out and you say, hey, I've got this dispute. Maybe it's not even a case at this point. It's you have a business, there's another business, and it's heading in a bad direction, and you'd like to try to mediate it and head that off and bring it in a better direction. It can be that simple. It can be a phone call or an email to say, how do I do this? And we will help. And it's a very informal process that can solve a lot of things, whether they're in litigation or never get there.
In a completely different setting, even if your marriage is in trouble, before you think about divorce, you may want to go to a divorce mediator because they may have the background to help you overcome your differences, almost acting like a social worker or a psychologist, but as a way of resolving disputes. And
there's, yes, and a lot of what mediation tries to do is to avoid a lot of the damage that disputes ordinarily can leave in their wake that goes beyond where things were when it started. The fighting makes it even worse. There are a variety of approaches, and you mentioned divorce and the family law stuff, which isn't really Marilyn and my thing, but we have colleagues, certainly, if somebody needed a referral to someone. But there are things like collaborative practice, and you just reminded me of that because they bring together someone who has the mediation background very often with a social worker, and it's a group approach, and that way they can try to address multiple different concerns that come into play in a divorce or in some sort of family law matter and minimize the damage and move everyone to a better place.
And what you've said applies to any type of dispute, a tort dispute, a business dispute, a neighbor dispute, some other landlord-tenant dispute. These areas can always be, there's no harm in trying to resolve these disputes through a mediation, which is in effect a discussion to try to get to the issues to a better place or resolve them or come up with the terms of the separation, whether it's a business or a couple or some other organization.
Any dispute or potential dispute lends itself to mediation. Oftentimes we will try to head something off from becoming larger than it is, which is why if you have something with shareholders who are they're not sure what they're doing. Are they going to dissolve their company? Are they going to bring it to the court to try and dissolve the company? They're having an issue. And we help them to resolve that so that they can move forward.
And you can be very creative in resolving the process with a plan that makes everyone happy or at least less unhappy. A judge may not have that creativity, may not have that patience, and may not have those options available to him or her.
That's why in mediation we look to what the real interests of the parties are as opposed to their positions. People take positions and they stick to those positions. But if you can determine what really is their interest, what is it that they're looking for, you can help them to get there.
And depending on the amount in dispute or the nature of the dispute, a person or business person or landlord might be able to proceed without an attorney, but a litigant can bring someone with them for support, and you'll let them in as long as they're not disruptive.
We're going to ask anyone who's there to sign a confidentiality agreement because that's one of the key elements of mediation, and we can talk about that more separately if you want, but that's the one thing that we would require. You can bring who you want to bring, but everyone's bound by confidentiality for anything said there.
And everything's going to be confidential. In the court proceedings, unless a judge rules it's confidential, it's going to be public information in perhaps a public courtroom.
Right. And we want people to feel free to speak openly. We don't want them to feel like it's going to come back to bite them down the road. And so we advise people up front, and it's in the mediation agreement, that things that are put out there as potential avenues to resolving the matter are not open for them to bring up in court later. That if they want to say, well, how about we do this? Or, I knew you were doing X when we were supposed to be doing Y. You can't turn around then. Somebody else can turn around in court and say, well, in the mediation, he said this. That's not allowed. And that's in the agreement. It's protected by the CPLR provision regarding settlement discussions.
And it's going to be a writing, everyone's going to agree to keep it confidential. And you also, they can always, if they're afraid of the other person or they're afraid of some ramifications, they will have, as part of the procedures, which we've discussed more fully in another show, they can speak to you privately, and you can listen to what they have to say, in a sense, privately.
That's something called a caucus, and we hold those almost in every mediation, unless you prescribe to a different type of mediation where they always keep people together. I don't particularly do that, but the thing that's important that I wanted to point out about the caucus, and what we make very clear, is everything discussed with us in caucus remains privileged unless you tell us that you would explicitly give us permission to speak to the other side. So we want them to feel comfortable saying whatever they want to say, and then we will say, is it all right if I go back and bring that up? May I tell them that you said that? What if I suggest this and I don't say you quite said that, but I'm making it my own suggestion? But nothing that is said in that, it's not just that the mediation itself when they're together is confidential. Everything in the caucus sessions are absolutely confidential and will never be repeated to the other side.
And that's not just a one-time occurrence, as is necessary during the process. Even if the process continues over different days, that is a tool that you have available. Someone can, it's like the confession or something along that line. The party can speak to you in privately, and then you'll based on your experience and your resources, you'll ask them if you have permission to mention certain parts of that with the goal of moving the dispute towards resolution.
And that's why it's called shuttle diplomacy, because you're going back and forth doing just that.
And it could be through Zoom or through a room or basically over the phone, whatever works for that dispute.
Absolutely. This is the parties process, which is why I also wanted to go back to something. If someone just wants to bring someone there, it may be that it makes them very much more comfortable, but people do things for all kinds of reasons, and you really need to flesh that out, because if it's someone that will create a problem for the other side, it's going to have to be something that is agreed to by both parties. We never force a party to participate in a mediation if there's someone coming that they don't believe belongs there. This is the party's process.
You work that out. Maybe they can wait in the car. They can wait down the hall. Maybe the person feels they need that person as a support person, but they can always, just like you can make your call on the game show, they can go speak to them and consult with them about something.
And they may just be in the caucus room and not come into it. We do try to find innovative ways to try to resolve those issues.
And you will protect each party from being a target of the other party. You're looking for a respectful resolution.
Mm-hmm.
It has to be a safe setting. I had months ago a wage and hour case in federal court where there was a supportive person there from one of the parties, but as soon as the other side, and we hadn't discussed the person's presence in advance, and in most cases we do discuss everyone who's going to be there for these reasons and others. But in this case, the person was a surprise, and clearly on the other side of the table, there was discomfort, and we wound up telling the person that he just had to wait in the hall. And if the person who brought him wanted to talk to him, they could do that on breaks. But for right now, there's some discomfort, and he's not a necessary party, and it worked out. And we went forward with him sitting in the hall waiting.
I just want to remind our listeners that you are listening to Law You Should Know on 90.3 WHBC Radio and also over the internet at nccradio.org. After this program, you can also listen to a podcast or tell someone else about the podcast at nccradio.org. We're talking with Jess Bunshaft. He's the head of Synergist Mediation, and also Marilyn Genoa, who's also oversees Synergist Mediation and is an experienced mediator and advocate on behalf of different clients.
Can I make one point?
Go ahead, Marilyn.
Sometimes people think that, this is too touchy-feeling, and listen to what they're saying. They're going to leave it up to the parties. But I just want to make certain that everyone realizes mediation is something that is used for the most complex. It's used for construction matters that you have 27 different parties. Mediation lends itself to every single type of case and every single type of format. How you go about doing it is dependent on the matter that you have.
And you'll fashion the proceedings to the needs of all the parties and to their schedule, rather than the alternative is a judge is going to say everyone has to be there with an expensive lawyer at 10 o'clock and just sit around till the judge is ready for you.
That is correct. And it is very different.
And Jess, let's talk about the process. That you're going to get a little briefing on the facts and the law beforehand from each party. And again, you can, depending on the nature and the amount involved, they may represent themselves. And if they're there on their own, you're going to help them. You're going to pull what information you need to understand what their position is and get them through the process.
That's right, Ken. We generally like to see people be represented because there are many instances, particularly if something's already in litigation, where an individual, unless they're a very sophisticated, perhaps business person, they may not know all of the risks and opportunities associated with the case going forward if they don't settle it. So legal counsel can be very important. But yes, I've worked with unrepresented individuals, pro se they're called, and we will help. We can't give legal advice. We can't put on our attorney hats. That's not our role. But we can help them certainly with the mediation process and with talking through what might be a good outcome from them. And whether it's a represented party or a pro se individual, we will have pre-mediation calls to discuss the process and make sure everyone's comfortable. And these days, since everything is online, we use the Zoom platform in our practice. We'll make sure they're comfortable with that as well. Then we will wind up asking the parties to give us mediation statements, regardless of the size of the case, because some of these can be new and some of these can be, well, as I may have mentioned before, we handle appellate matters. These are huge with big records on appeal and all that, but the mediation statement is meant to be a short overview, 5-10 pages maybe, to give us the high points of the matters in dispute, the damages that are being alleged, the opportunities, the risks, and so on. And these are confidential. We will ask each party to give this to us in confidence. We will not share it with the other party. If there's any piece of it that a party wants to share with the other party, they're free to do so. But this is to advise us. And the reason we need this is, for one thing, so we don't waste time doing too much research up front to try to get up to speed with your case, but also because we need to be empowered with the important points of the case so we can best facilitate the discussion between the parties and speak as helpfully as we can in the individual caucuses to test out positions and to say, well, I hear what you're saying, but what about this? And this, while we may not say, well, the other side told us X, Y, Z, may be fueled by that. In the backs of our heads, we know that this is a concern that both parties know about, so we can raise that with the party we're talking to and say, well, how are you going to handle this? Let's talk about that. That's part of the process.
But also, the pre-mediation statement has a lot of importance because it forces people to sit down and actually think about both sides. As I will often say in discussion about it, everybody thinks their case is a winner, but everybody really understands, at least attorneys do, that there are downfalls to it as well. And we're asking them to put that into the mediation statement. Let us know what you know to be potentially something that may create a problem, and put your thinking cap on. Try and think of something that you believe may help move this forward, because that alone is an impasse-breaking thing. If you have, while they're doing their pre-mediation statements, it is helping them to move forward in their thinking so that we avoid impasses later on.
And Marilyn, how are you going to start bringing these problems, the parties toward resolution? You have the mediation statement, you've had your opening introductions, etc. You've heard from each party. How are you going to pick out something to start with to try to? You're going to break down the problem into little problems.
To them, and we're going to say there are things that you do. You can repeat things that you've heard. You can say, "I heard you say this." Why? What's happening? What do you feel about that? There are a lot of discussions that you can have when you get into the private rooms. You can even look at them and say, I saw that you were concerned when the other party made their opening that this was an issue for you. You wanted, can you tell me more about that? In order to bring out some of the feelings and some of the issues that are there.
And Jess, do you want to try to find some easier issues to start with to try to tentatively resolve those issues to move on to more complex? Do you want to pick out from each side what is most important to them in resolving this dispute?
Yes, you hit the nail on the head in a lot of ways there. You do want to try to find things that are the low-hanging fruit and try to resolve things to get some momentum going. One of the things about Marilyn used the term impasse, and that's a word that we don't even like to contemplate because that means we've really gotten stuck. And we try not to get there. We try to keep things moving forward. We have a whole bunch of tools in the toolkit for trying to break impasse and get things moving forward again. But getting that momentum going and maintaining it is one of the keys to moving things along. Everybody likes to feel successful. And so even if you have parties coming at things from different positions, if everyone feels like, oh, okay, we got that done and it's resolved and let's make a little note and move to the next thing and so on, that positive feeling, that motion forward is what can move us on to resolving everything.
So you've created momentum, you've gotten some issues resolved that each party is happy with, and you're trying to find a middle ground or find out what each party needs in terms of those other issues and which of them are really important to them.
Right, and then it depends upon where we're at and how long we've been at it, and a lot of it's trying to read the posture and emotions of the people you're dealing with, whether people are feeling hopeful or fed up or whatever, and then trying to judge where you can go. If you feel like you've been getting some movement as the mediator, but you're not getting enough movement. You're getting little itty moves, and it's like, okay, guys, this isn't really getting us where we need to go. You might try then to get, depending upon how far the parties are apart, and we could do a whole show on that, and I know you don't want to, we could then try to use something like bracketing, where we're going to say, well, okay, you're this and they're that. If I can get them to move to, and you throw out a number that's not too big of a move for the other side, but is significant. If I can get them to move to this, if the plaintiff can come down to this, would you come up to that? And they'll say, well, okay. And then you go to the other party and say, look, if you'll come down to whatever the number was, I can get them to come up to this. If you can get them to start talking that way and get a significant move from both sides and get them into a range, that can change the atmosphere, and that bracket that you'll work within then creates a different atmosphere for the whole thing and can suddenly create motion. There are things like helping a party analyze their case. I might start working on a decision tree analysis with them where we look at the various risks, likelihoods of success, how damages might play out, whatever the case may be. And maybe we start talking about alternatives. Other things of value. We say that mediation is forward-looking, whereas litigation is backward-looking. Litigation just looks to address wrongs that were done. Mediation, we look for opportunities going forward. Is this a business dispute where maybe the parties still want to be able to work together, or maybe they have opportunity to work together if they can resolve this and move forward? Let's talk about what that would look like. And
that may be true in a divorce too, where they each want the children to get certain things, they want the other party to have certain things, but they need some for themselves. We're going to go to you, Marilyn, on that, but I just want to remind our listeners, you're listening to Law You Should Know on 90.3 WHPC Radio. You can also hear the podcast of this or other shows from WHBC at nccradio.org. We're talking with attorneys and mediators Jess Bunshaft and Marilyn Genoa. So, Marilyn, are there other ways to bite off pieces to try to get some movement among the parties on easier issues before you go to the difficult ones?
There are. Every case is different. There are, we'll often look at them and have them work on what's the best alternative to a negotiated settlement. What's going to happen if you don't get this settled? What are the things you're going to be dealing with? How, and have them face things realistically. It takes a lot of listening. You refer to, and although we don't do matrimonial, we certainly have a lot of colleagues that do, and I know that with matrimonial matters, listening and hearing the caring from the different parents as they're fighting over who's going to get this, and it's, well, what I'm hearing is you're both concerned about what's the, how this is going to work for the child, and you both want their best interest, and sometimes that's enough to get them to back off a little. So, and you can do that with a business divorce is the same, and that's my area.
And that could be true with a business dispute or a neighbor dispute or someone who's been a victim of a crime, some kind of property crime or landlord-tenant matter as well.
Right, because oftentimes, not always, but I would say a good deal of the time, there are relationships involved, and some of those relationships are people. You'd be very surprised if you say to someone, "Well, could you?" And this is another tool that's used. Is, "Well, would you be interested in continuing a relationship with them?" And the person will say, "Well, I would if," and then the other party is they want to continue, and then they wind up not only resolving that dispute but placing purchase orders with each other for future orders. So being able to listen, being able to circle back, being able to reframe the things you're hearing is really very important.
Or could it be being involved in the business in some way, but maybe not as a partnership? Go ahead, Jess.
Absolutely.
And that also applies very often to employment disputes, be it, and one of the things we do is helping companies in-house where you have a manager and employee who you both want to keep, but they're at each other's throats, and you need to find a way forward. You can help resolve there, but also with employment litigation. I mean, sometimes it feels like all the bridges have been burned, but then you talk to the plaintiff who, was a good place to work until XYZ happened. And if it's a big enough organization, especially, even if, with one person or one area, it's not a comfortable place for this person to work anymore, maybe there's somewhere else they can work within the organization. And when you can offer an opportunity going forward, suddenly, the seeking of a payday isn't such a big thing. It's not, they fired me and they shouldn't have, and so you have to pay me X dollars. If you show someone a future, and assuming, the defendant's agreeable and so on, it's a whole different thing. Then the future isn't so black anymore, and now we can start to talk turkey and resolve things. So it works in a variety of cases, employment and all the others you discussed.
And you can help them to maintain some sort of relationship or part or agree to separate in a fairer resolution than if they just went to court.
Absolutely.
Okay. Marilyn, just tell us for a moment about your own mediation business and your background and contact information.
Okay. I'm going to leave the contact to Jess because he's much better at that. But my background is beginning as a commercial litigator representing businesses. I was a CEO of a manufacturing company. So I have a lot of involvement with business, with real estate. But I've always felt that settlement and mediation, I've been doing this for 20 years, was important, and it helped people actually move on with their lives. Jess had felt the same way, which is why we came together a while ago, a couple of years ago, to form Synergist Mediation. Because of both of our backgrounds meld very well, it gives us the opportunity often to do co-mediations, and because I think it benefits the parties. We each have a little bit of a different viewpoint, and it allows us to get to the results much more quickly. But it is something that I have been a firm believer in, and I know from experience that 95% of cases never actually go to trial. So if we're going to resolve them, why not do it up front before you spend all of that money?
And also your emotion, your high and low of emotions during a traditional litigation. Just tell us about yourself.
We're both experienced attorneys, but as Marilyn said, we're both very much dedicated to mediation and what the process can bring at this point. So our firm is called Synergist Mediation, SYNERGIST Mediation, all one word, .com is our website, and you can reach us right through there. All of our contact information is there. We handle a whole variety of cases, most of what anyone would encounter, except, as we mentioned, matrimonial, and we certainly know people we can send you to or recommend if necessary. We have dedicated ourselves to bringing quality to the practice. We're both extensively educated in mediation, very experienced in mediation in a variety of settings. We're trusted by the courts, from the courts in Nassau County to the appellate division, to federal matters I deal with. Marilyn herself is a judge. And all of this experience is there to help resolve cases. And we offer things that some of the big boys, there are major firms that have lots and lots of mediators on their panels, but we don't charge we don't charge administrative fees at all, actually. Our rates are competitive, and we can offer you co-mediation and blended rates for that make it very effective and very affordable. So that's what we're bringing here, and we hope lots of people will see value in that.
Marilyn, anything that you wanted to add?
Just what I say to everybody when we're doing our openings. I am, and obviously we all wear various hats, but I am a litigator, I'm a judge, and I'm a mediator. And when you have a dispute, you really want to be before me as a mediator, because the end result is going to be something that is going to be less time-consuming, less financially impacting, and will let you walk away with something that you can actually...
So the emotional resolution is important, too. I'd like to thank Marilyn Genoa and Jess Bunshaft of Synergist Mediation for being our guest today and describing the ADR and the mediation process. You've been listening to Law You Should Know on 90.3 WHPC. If you've missed any part of this program or other programs about the law or about ADR, Alternate Dispute Resolution, just go to nccradio.org, and please join us next week at the same time for another program on Law You Should Know.